Bismillah ar-Rahman ar-Rahim. So the name of the book is Visions of Sharīʿa, which is a co-edited volume of a number of essays, which I edited with Professor Michael Bohlander and Dr. Lawrence Darouj, both of Durham University at the time of the conference that this book came from. So the book is a compilation of essays which started at a joint conference in 2015, which was organized between the Al-Mahdi Institute and the University of Durham. And the motivation behind the book and the conference actually came from the co-editor, Professor Bohlander. So Professor Bohlander is a good friend of ours. He's a illustrious legal scholar. Yeah, he's a chair in comparative and international criminal law at Durham. He's had various roles as a judge. So he was appointed to the courts of The Hague following the Kosovo conflicts. He spent 4 or 5 years as a judge at the extraordinary chambers in Cambodia. But he also has a serious interest in comparative and international law, and had done a lot of work in Sunni jurisprudence and comparative law in terms of Sunni thought. Now, he had participated in a conference that we'd held at the Al-Mahdi Institute, probably in 2013 or 14. And as he mentions in the preface to the volume, so he writes this in the preface actually, that the majority of the academic field and the majority of actually the popular consciousness, amongst non-Muslims regarding Islam and Sharia is in light of their understanding of Sunni jurisprudence. And so he wanted to help us and encourage greater attention to Shia legal theory, particularly because he was so surprised, and this is a comment he makes in the preface, by the ease and the mastery that contemporary Shia scholars of legal theory had over European thinkers. So in the conference which he attended, which was a workshop to do with fiqh, and I think it was on the status of non-Muslims in Islam, if I remember correctly, he was shocked actually that these jurists or people who were engaged in the study of Islamic law, the teaching of Islamic law from a Shia perspective, could quote from Kant, Hegel, Schleiermacher, and Kierkegaard, with ease. And so he came to me after the conference and he said that actually, we need people to be more aware, just as these thinkers are aware of European thought. We need to create greater attention, or we need to encourage greater attention, to the intellectual discourse which is internal to Shia thought itself. And so he wanted us to give a window onto the rich and vibrant field of Islamic legal theory, as a living intellectual discourse. I think this is one of the major contributions of the book, is that it brings together essays on Islamic legal theory and different topics in usul al-fiqh, of course, from a Shia perspective, but not with a purely historical interest. So if we see the history of the academic engagement with Islamic law generally, Sharia more particularly, and of course, Shia approaches to Islamic law, it's largely historical. There's been very little literature on legal theory or usul al-fiqh in the contemporary phase. And we wanted to engage with this intellectual discipline, as a lived tradition and as a vibrant tradition. So usul al-fiqh, which of course is the focus of the contributions here, even when we look at the typical definition of usul al-fiqh given from an insider Shia perspective, it's often defined, it's defined in various ways, but the usul al-fiqh is the study of the common elements, in the inference of Sharia rules from their sources. So it's about discipline which engages in the study of the method and methodology behind ahkam al-shar. Now, in that process, we see that the lived I would call it a tradition, the lived tradition of scholarship in usul al-fiqh contributes much more than just a legal theory. So within usul al-fiqh, and this, I think this is true historically, and definitely in the contemporary period for Shia thought in particularly, we see that it's within usul al-fiqh that we find the richest discussions, arguably, for the dominant epistemological and hermeneutical ideas of Muslim thought. So the dominant ideas about the theory of knowledge, the dominant ideas about how to interpret not just texts, but ideas, even the world, okay, are actually rooted and found within the discourse of usul al-fiqh. So we wanted to shine a window into, contemporary discussions, okay, within this remit. Now, within modern Shia thought in particularly, arguably, or at least in my view, the discourse of usul al-fiqh, of legal theory, is not just the foremost forum. I know philosophers and theologians, from within the tradition may well disagree with me, but in my view, for modern Shiism and contemporary Shiism, usul al-fiqh actually doesn't just provide the most vibrant forum for epistemological and hermeneutical questions and thinking, but also for pure philosophical and theological thinking. If we want to find, for example, some of the most cutting edge discussions about the nature of God's will as opposed to God's predetermination and human free will, actually we often find them within treatises written by the ulama, which are deeply hidden, okay, within advanced works of legal theory. Questions of pure moral philosophy about the nature of morality, for example, okay, are hidden, okay, within the most advanced works of legal theory. And of course, legal theory has this very sharp impetus towards, giving us, as I said earlier on, discussion of the method and methodology of inferring, those basic presumptions which Muslims carry, that there is an ideal way to live, and there is an ideal way to respond to each and every situation. How do we understand that ideal way to respond to each and every situation is what is studied in usul al-fiqh. So it was a great privilege to be part of the project, and that kind of hopefully gives you a sense of the motivation behind it.
And thank you, Dr. Bhojani, for such comprehensive and detailed information and background about the book. My second question is about the structure of the book, the content of the book, the main arguments of the book, and as a whole, the structure and layout of the book. How is it starting and how is it concluding?
Sure. So as I mentioned, it's an edited volume, so it's a collection of essays, and there are 7 chapters in the book, an introduction, okay, and some appendixes, right? So I'll try and take us through step by step. So the idea was, as I pointed to, is to try and give a window into kind of the breadth, of intellectual vibrancy, okay, within contemporary discussions, within legal theory, within Shia legal theory, and actually also see how the discourse of legal theory is used as a platform for discussions around epistemology, hermeneutics, okay, and some very, very pressing ethical questions within Islam. So the way the book is structured is it's 7 chapters from 7 different scholars, and which reflects actually, again, this shifting and live and vibrant discourse of usul al-fiqh, because it brought together, a variety of very, very different scholars at different stages in their careers, including some who spoke with, great authority, trained to the very highest level in the places like Qom and Najaf. Others, we had professors from, with a purely academic background, and from, for example, Professor Haider Al-Ahmoudi from Pittsburgh. Then you also had young scholars, emerging scholars who, if you like, have a hybrid background, being trained in a seminary context, as well as having academic training at universities and holding PhDs. So there's 7 chapters, I'll take you through each of them. It's framed with an introduction, which I wrote. Now the introduction, so if I start with the introduction and then say something about each of the chapters and mention their author. So the introduction seeks to very, very briefly, survey the field of English scholarship on Shia legal theory. So it gives us a brief overview of what's already out there when it comes to Shia legal theory, usul al-fiqh and Shia thought. And unfortunately, it's a very, very open field, so there isn't that much out there. It also seeks to contextualize the contributions of the book, and not just in terms of in the academic literature, but also Shia legal theory itself. So I referred in the introduction to a very interesting, albeit brief, account of the history of Shia legal theory, which was taught by Sayyid Sistani in his and has been published in the introduction to one of his advanced courses of Usul al-Fiqh, published as a Rafid fi Ilm al-Usul, which we've also translated, a few pages from that section as an appendix in the book. So I refer to that introduction of Sayyid Sistani, where he discusses 3 phases to the history of Shia Usul al-Fiqh. Now the first, and this is something which is very novel, actually, and actually very interesting, which Sayyid Sistani gives in terms of his classification of history. So, there's different ways we can classify history. And for Sayyid Sistani, he gives us this periodization of Usul al-Fiqh in terms of periods of intellectual struggle. So he says, look, we can mark out shifts, okay, and periods based on the nature of intellectual struggle that was going on at any time or in any place. And so accordingly, he says, look, we can identify 3 distinct phases of intellectual struggle within the history of Shia legal theory. Now, the first intellectual struggle, Sirah Fikri, I think is the term that he uses, the first intellectual struggle that he describes, which characterized the output of Shia thinkers and scholars in legal theory, was in response to intra-Muslim dynamics. So basically, from the time of the Imams themselves, okay, all the way through to the 16th century, Sayyid Sistani says that Shia scholars were basically responding to the influences of and the different methods of interpreting Sharia that were around them, okay, amongst other Sunnis, okay, and other Muslims, okay, whether this was the very early tensions between, the schools or the approaches to understanding Sharia which privileged, personal reflection and personal preference and non-textual reasoning, okay, or whether it was those who, were, more textualist in their approach, okay. So Sayyid Sistani says this first intellectual struggle, okay, was the Shia engagement with, okay, scholars of other schools of thought. So if we see, for example, Sharif al-Murtada is sometimes credited with producing the first complete work of Usul al-Fiqh within Shia thought. Others would say it was Shaykh al-Tusi's al-Udda fi Usul al-Fiqh. Some would say it's Sharif al-Murtada's, and there's an academic debate there, which I won't go into here. But if we look at Sharif al-Murtada's al-Dariya fi Ilm al-Usul, we see he is actually engaging throughout with the views of non-Imami Shia scholars, all right, in that work. Okay, so it's positioned as a work in the context of Sunni thought more generally. We go all the way through to the time of Allama Hilli. Okay, and Allama Hilli in his, extensive output when it came to Usul al-Fiqh is again dealing with the cutting edge ideas that were being developed, debated, contested, again in broader Sunni thought. So for Sayyid Sistani, the first period, okay, goes right from the time of the Imams all the way through to the 16th century, and it's characterized by a Shia intellectual struggle in responding to intra-Muslim dynamics of theory. He says the second phase, okay, is the characterized by a inter-Shia dispute and an inter-Shia intellectual struggle. And this is that famous Akhbari Usuli debate, okay, which was kind of epitomized in the works of Mullah Muhammad Amin Asrabadi, okay, in the 16th and 17th century Common Era, you know, who was the champion of the Akhbari school, and you know, the likes of Faiz Kashani, and ultimately, you know, more moderate Akhbaris like Sa'ib al-Hadaiq al-Nadhira, Yusuf al-Bahrani. So these Akhbaris were responded to by the Usuli tradition, an Usuli tradition which was championed by, of course, Wahid Bihbahani. Sayyid Sistani quotes, you know, the important contributions of Wahid Bihbahani, Mirza Qummi, Sahib al-Fusul, culminating in the works of the giant of modern Shia Usuli thought, Murtaza Ansari. So for Sayyid Sistani, we have a first intellectual struggle or first period of legal theory, was the Shia response to the wider Muslim discourse in legal theory. The second intellectual struggle which shaped the development of Shia legal theory was an internal struggle between which arose out of these two tendencies, the Akhbari tendency and the Usuli tendency, which would come to dominate and culminates in the works of Sheikh Murtaza Ansari. He then moves to the third of his three periods. And this is what helps us contextualize the contributions in this book, and why we included mention of it in the introduction to the book. I decided to include a translation of this discussion as an appendix. Sayyid Sistani says the third phase in the history of Shia legal theory is the contemporary phase. This is the intellectual struggle which characterizes the contemporary phase of legal theory, which he's positioning as after Murtaza Ansari, okay, is characterized by, due to various political factors and economic factors, the Islamic culture and heritage finds itself in a deep struggle and needs to move its engagement with theoretical questions behind Sharia, okay, to respond to these contemporary challenges. So it was within this context that we thought it was, you know, a great opportunity for us to give a window into some contemporary thinking, okay, in Shia thought. So that gives you a taste of the introduction and a sense of Sayyid Sistani's periodization, which hopefully gives an insider context, actually, okay, to why Shia scholars see legal theory not as a historical discipline, okay, or as a dead discipline and as a static discipline. No, arguably it has been, you know, the most important discipline, and rightly or wrongly, okay, within Shia seminaries, okay, for generations, and continues to be so. So I think that takes us, you know, to saying something about the chapters within the volumes. So the first chapter is written by Ayatollah Professor Muhakkik Damad, who of course is an you know, illustrious scholar, a member of the Academy of Sciences of Iran, and a professor in the Faculty of Law at Shahid Beheshti University. His contribution here is titled "The Reception of Factuality Theories of Ijtihad in Modern Usuli Shia Thought." So this chapter actually discusses the theoretical framework for ijtihad, and ijtihad being, and very simply, if you like, the efforts of a qualified jurist to interpret Sharia from its sources. Now, the whole idea that we need ijtihad, or that there is a need for ijtihad, so there's a need for expert intellectual effort to interpret the sources of Sharia, kind of presumes that the sources are not absolutely clear, okay, and that there is a possibility for difference of opinion. So now the theories of ijtihad which are discussed in this chapter, okay, were a response to try and understand that diversity. And this isn't a question which only engaged with, you know, it's an early classical question, you know, in legal theory, saying that, look, if there's diversity of opinion, okay, regarding, you know, how we ought to live, how we ought to act, what's the limits of that diversity of opinion? Okay, and how can we get our head around that? How can we theorize, the reality that if sources of knowledge, okay, are not absolutely definitive, this is going to give rise to difference of opinion. How much of this difference of opinion can be legitimate, and how much of it can't be legitimate? Okay, and how does this work anyway? In terms of us trying to aspire to understand, as is the remit of the jurist, the rulings of God, and the way that God wishes us to act in any given situation. So that gives you a taste of what the debate is about. Now, Ayatollah Muhakkik, what he examines is a particular theory of ijtihad, which is referred to as tasweeb, okay, or factuality theories of ijtihad, which is typically associated with the non-Shia Imami position. So Imami Shia scholars are rhetorically very, very strongly proponents of the takhta'a theory of ijtihad, which basically means that, mujtahids are fallible, and mujtahids make their best efforts, okay, to try to discover a ruling which is correct in the knowledge of God. Now, if the efforts of the mujtahid miss the truth, okay, they can still be valid, and they can still be a valid excuse before God, as long as they're a result of a procedurally sound and rigorous method. So the takhta'a theory suggests there is a correct opinion, okay, and the results of the jurists, okay, are reliable, okay, can be authoritative, okay, even if they don't get things right. Yeah. Now, Sayyid Muhakkik actually looks at the contrary theory, the theory of tasweeb, okay, which was very prominent amongst some of the Ahl Sunnah, which suggests that whatever the mujtahid infers is the truth and is the correct position. Of course, the proponents of tasweeb only advocated tasweeb where the evidences weren't explicit in the Quran. But Sayyid Muhakkik's actually aim in this chapter is to demonstrate that despite Imami Shia having a strong rhetorical, affirmation for takhta'a fallibility theory, okay, there has been influence of the tasweeb theory upon Shia thought, citing the likes of Akhund Khurasani and some of the most sophisticated ideas actually that we see in Sheikh Ansari's work, his theory of maslaha sulukiya, which is sometimes described as the Shia tasweeb. So in this way, Sayyid Muhakkik actually demonstrates that there's certain questions which may have been perceived as closed, and settled within Shia legal theory, which are actually open. Okay, and not only does he set out this precedent to say that theoretical questions which seem closed and well settled, are open. They always have been open, and they can continue to be reviewed and reconsidered. And he points to the influence of developing tasweeb theories in a variety of ways, including in terms of understanding religious plurality more generally, where he refers to the ideas of Muhakkik al-Qummi. So I think that's plenty to say about the first chapter. I should say something now about the second chapter. So the second chapter is written by our colleague and friend, Dr. Hashim Bata, who's a graduate of the Al-Mahdi Institute and has his PhD from Warwick University. And his chapter is looking at some questions which maybe lead on from the first chapter quite nicely. Because if we're asking in chapter 1 about the theory of ijtihad, in light of not all sources of knowledge being absolutely definitive, Dr. Hashim asks the questions, okay, so what is it that allows us to rely upon a source of knowledge anyway, when it comes to seeking knowledge of the law or knowledge of God's rulings? So here, Dr. Hashim highlights very, very clearly and problematizes, the dominant epistemic assumption, in modern Shia legal theory. So in modern Shia legal theory, to try and sum it up, and this is particularly within the school of Sheikh al-Ansari, or the positions attributed to Sheikh al-Ansari, is that a source of knowledge, okay, with regards to Sharia, okay, or Sharia ahkam, it is authoritative, is reliable, okay, is a hujjah, okay, when it is either certainty bearing, yeah, it gives qat, it gives the jurist, certainty, yeah, or there's a certain validation for that source of knowledge. Okay, so we can rely on two types of evidences. One type of evidence is that gives me certainty directly, and another type of evidence which might not be certainty bearing in itself, but has a certain justification behind it. So Dr. Hashim quite clearly outlines this premise. Okay, looks at its philosophical underpinnings, looks at how it's been received and challenged, okay, by some pre-Ansari scholars and some post-Ansari scholars, the likes of some of the very philosophically rich discussions given by the likes of Ayatollah Khomeini on these ideas, Ayatollah Shubayri Zanjani, okay, as well as some of the other commentators, and actually looks to problematize the basic epistemic assumption driving much of modern Shia legal theory about the intrinsic authority of certainty, and how if the Shia legal theory wishes to continue to be philosophically rigorous, it needs to ensure that its epistemic assumptions continue to be philosophically rigorous. In his view, reassessing these epistemic foundations would open up the arsenal of the jurists to refer to, as he puts it, a wider range of evidence in the inference of Sharia precepts. So hopefully that gives us an insight into Dr. Hashim's contributions, and I should say something about subsequent chapters as well before I run out of steam. So the third chapter is, I think, in my view, one of the outstanding contributions in the volume. It is written by Ayatollah Dr. Rahim Nobaha, who again is one of the senior lecturers at the Institute, although he's based at Shahid Beheshti University, and an expert in criminal law. The work, follows very much the remit that we initially asked him to speak to at the initial conference, examining the role of the Quran, okay, in ijtihad, okay, from a Shia perspective. Now, he touches on a number of very, very important and in some cases seriously under researched. So it starts with a discussion of this interesting tension that the nature of revelation, okay, according to Shia philosophers, has been something very difficult to understand. And those who are interested in Shia theology and philosophy will be aware that this is a vibrant area of debate and contestation, amongst Shia scholars about the nature of revelation itself. Now, Dr. Nobaha here in this chapter points to an interesting tension that despite, some theological and philosophical deliberation about emphasizing the fundamentally divine nature of revelation, which is of course the dominant mainstream view in Shia thought that revelation is something ultimately divine. Okay, and this was a revelation which the Prophet received purely as a recipient. Its nature is otherworldly. Yet, okay, from a legal point of view, okay, for the legal theorists, they treat it as ordinary language, right? So he sets out his contributions, okay, by framing this fascinating, we could call it tension, that there's an assumption that the revelation is fundamentally divine and otherworldly, yet when it comes to interpreting the Quran, okay, the whole system of Islamic jurisprudence, depends upon, ordinary, conventional use of language and applies the principles determined from the ordinary use of language to its interpretation of the Quran. He then moves to discuss, and again, it's a very under-researched area, and if you like, this is a preliminary contribution, and I think Dr. Nobaha really opens up this discussion and his his footnotes are a treasure trove of information for the interested reader and researcher. He then has a short discussion about the history of the scholarship on the Ayatul Ahkam within Shia scholarship. So a discussion of those verses of the Quran which have legal import. What's its history? What have been the key contributions? So on and so forth. He then moves into this major discussion about the role of the Quran in ijtihad. And of course, this becomes positioned again, largely within the Akhbari Usuli debate. Okay, and he of course although he gives a rigorous defense for the centrality of the Quran within ijtihad, a note which I make in the introduction, the fact that it needs defending, okay, suggests something. And so there is a controversy there, actually, as to which really is the primary source in modern Shia jurisprudence. Is it actually the Quran? Okay, or is the Quran taking a secondary place, okay, in light of the prevalence of historical precedent, okay, or of course the interpretation and application of a sunnah and a hadith. Dr. Nobaha gives a defense for the centrality of the Quran in ijtihad, but finally concedes something to the Akhbari view, saying that the one thing that we have to be careful with is that by opening up the centrality of the Quran and emphasizing the centrality of the Quran as a source of normativity, a source of ethical and legal guiding principles, and we have to be careful that it still requires, in his view, expert interpretation, okay, and that there's a risk that the Quran, when read, okay, superficially, okay, can actually become, a source of misguidance. I think that moves us to chapter 4. I'm just looking at the time. Chapter 4 is again a colleague of ours, Dr. Imran Ali Panjwani, who was a graduate of the Al-Mahdi Institute, an independent scholar working in the legal forums here in the UK. His chapter is titled From Theory to Practice: The Role of the Subject in the Derivation of Rulings and Its Potential in Creating a System of Case Law for the Operation of Shia Law. So what's central to Imran Ali's concern here is to, again, try and broaden the input or broaden the theoretical consideration, okay, over the things informing the inference of ahkam, okay, and the production of ahkam. And I think he brings his own legal experience and legal knowledge, okay, to his approach here. So he focuses in particularly about concerns regarding what we call the subject of the law. Now, typically and traditionally, ijtihad is concerned with identifying ahkam, the rulings, inferring, as I said earlier on, a definition of usul al-fiqh would be, the study of the common elements involved in inferring the ahkam from their sources, right? But of course, studying, for the practice of law, knowing the ruling isn't enough. The subject to which we apply the ruling also has a huge influence in the way the law works. And Imran Ali's concern is to actually try to open up space within legal theoretical deliberation, within usul al-fiqh, to consider more carefully the role of the subject or the mawdu' in ilm al-usul. And he identifies in particularly, okay, or focuses on or calls for greater attention to the notion of bana al-ukala, okay, ordinary rational convention, as a basis for considering case law and precedent to have a greater theoretical role, or to have a greater platform or greater consideration on in usul al-fiqh. Chapter 5 is by Professor Haydar A'la-Hamoudi, who is I think he's now dean of his law school in Pittsburgh. So the bio that we have here is I think out of date now. So he's now dean of the University of Pittsburgh Law School, whose scholarship focused on Middle Eastern and Islamic scholars. in Islamic law. He's prolific writing on Islamic law, has an excellent blog on this. It's very accessible to those who are interested in looking him up. And he writes, very engagingly. So I'd recommend that people look at his other work. So Professor Haidar's contributions, move us a little bit away from the discourse of usul al-fiqh directly, okay, and is looking actually about raising questions for legal theory. So rather than looking at the discourse of legal theory, he's looking at socio-political circumstances, okay, which raise questions for legal theorists. And he identifies, I think, a very, very important phenomenon, which he calls strategic juristic omission. So Professor Haidar examines and discusses how we find in the output of jurists, okay, leading jurists of our day, okay, some tensions between the legal systems of their lands or the lands of their followers, the views, okay, of the followers, the actual legal doctrine or fiqhi doctrine which the jurists have historically promoted. And he suggests that one of the ways that the jurists have responded to this tension between the socio-legal frameworks, the, if you like, demands, if I put it in that crass term, yeah, of the opinion-seeking Muslim, and the historical views of the jurist themselves, which the jurist is a guardian of, or a bastion of. One way that they deal with this tension is to actually strategically omit some of their views from their pronouncements. He gives a number of examples. He talks about, for example, the views of scholars regarding marriage and regarding slavery, for example, without actually having rejected historical views and saying that they no longer hold them, or that they don't consent to them, or that they think they're invalid, okay, they omit them. Now, the focus of the chapter is on the blood money, okay, and apparently, I think it's fair to say, actually discriminatory rulings in historical Shia fiqh regarding the blood money of a non-Muslim, and how this actually sits in tension with, the outstanding and actually sometimes landmark statements of the Maraja, okay, in the context of contemporary Iraq, okay, and ISIS, and regarding, the equality of Shia and Sunni, okay, yeah, Muslim and non-Muslim, okay. So he highlights the ecumenical statements of the ulama, particularly in the Iraqi context, okay, in their response to Daesh, okay. He then looks at the historical discriminatory rulings regarding diya, okay, and the tensions, okay, in terms of the local rule law in Iraq, which doesn't make the same discriminatory distinction between the blood money, okay, of the Muslim and the non-Muslim, okay, and then raises questions for the jurist. Okay, there is strategic juristic omission. Is the jurist simply not stating their view, all right, sufficient, or do they need to explicitly reconsider their views? So that hopefully gives us a sense of the very provocative, engaging, and thoroughly researched chapter by Professor Haidar Hamoudi, which takes us to the 6th chapter, which was my own contribution, titled Towards the Hermeneutics of a Justice-Orientated Reading of Sharia. So here, I'll try to be brief now. The basic premise of the chapter is one which I explored in my earlier book, Moral Rationalism and Sharia, which seeks to explore the space within Shia jurisprudence for reason as an independent source of Sharia rulings. And not just any form of reason, it's of course particular moral judgments, okay, regarding Sharia. The premise is that, of course, if Allah subhanahu wa ta'ala is just in a humanly understandable way, okay, then surely his actions are just, okay, and his rulings are just. Now, what happens if we have rulings which are inferred from the scriptural sources of Sharia, which are apparently immoral, okay, to the human mind? So the chapter looks at how usul al-fiqh might help us, okay, reconcile apparent tensions between judgments of potentially relevant judgments of human morality, okay, yeah, and inferred human judgments, okay, of scriptural norms, yeah, based on the premise that we can't attribute an immoral ruling to a just God. And I suggest a three-stage hermeneutic, okay, where if we have an apparently or potentially valid judgment of human morality, that a particular ruling is immoral and can't be attributed to a just God, okay, we need to go through a three-step process of reconciliation. First, we need to try to assess, okay, is the scriptural source or the scripturally based ruling, okay, could it be understood as potentially moral in its own context? If so, yeah, we would seek to reconcile both evidences and consider the scriptural evidence as contextually specified. If that isn't possible, we seek to reread the scriptural source. And if there's a reasonable, okay, reading of the scriptural source away from the apparent meaning, which is consistent with the moral evidence, okay, we would reread the scriptural source. And if, okay, that isn't possible, then ultimately, yeah, we would do tawakkuf or tasakut of the adillah. We would either withhold our opinion or drop both evidences. And I tried to give some groundings for such a hermeneutics from within the discourse of legal theory and with some illustrative examples. The final chapter is by Sheikh Dr. Hassan Balushi, of Kuwaiti origin, who is a teacher in the Hawza of Karbala, holds a PhD from the University of Exeter, and gives us this very, very important contribution on the Maqasid al-Sharia discourse in contemporary Shia jurisprudence. So Maqasid al-Sharia discourse is, of course, very, very important in Muslim thought more generally, has been historically and increasingly so, where it seeks to very simply privilege the objectives of Sharia over its particular form. Now, Sheikh Hassan, Dr. Hassan looks at the historical development of Maqasidi type thinking in Shia thought. He points to how some of the actually, and contextualizes this against the broader development of Maqasidi thinking within the Sunni world by the likes of Shatibi, which developed in a very different way ideas which we earlier see in the likes of Al-Ghazali. And Sheikh Hassan, I think, correctly notes that some of the theological infrastructure for a maqasid, for a vibrant maqasid discourse, which seeks to make reference to the intentions of Sharia or the purposes of Sharia, is very much sustainable, okay, within a Shia theological worldview, where Allah subhanahu wa ta'ala is one who not only works with justice, but works, as the previous chapter relied upon, but works with purpose, okay, and with hikmah. Okay, so this theological foundation, which is fundamental to Imami Shia thought, is of course one which ought to be ripe for a maqasid type discourse, and one which isn't always held by proponents of a maqasid discourse in the wider Muslim thought. So Sheikh Hassan points to that kind of theological tension and opportunity, yeah, or the fertile ground for a maqasid discourse, looks at the historical development, okay, and identifies how it's been very, very different in a Shia context, and actually relates it to some of those major epistemic questions which were touched on in a different way by in Dr. Hashim's contribution, and grounds it with the socio-political concerns which came about, for example, with the Islamic Revolution and changes in the Iraq, and points to the possibility and likelihood or otherwise of a fuller maqasid discourse being developed, okay, within Shia thought. Finally, we have an epilogue by Professor Robert Gleave, who is, he's a leading voice of academic Islamic law, and whose specialism is Shia legal theory. And although he didn't participate in the conference from which this volume emerged, we thought it would be nice for him to comment on on the contributions. And I think he rightly identifies that the contributions within this chapter, as he puts it, represent some of the more adventurous side of Shia legal theory. And he translates and offers us a section of a text by a contemporary jurist, Ayatollah Subhani, Jafar Subhani, which again deals with some of the epistemic questions which came up in a number of chapters about the authority of certainty or the authority of conjecture, or in Ayatollah Subhani's view, the non-authority of conjecture, okay, as a balance to some of the discourse within the volume. But I very much hope that that has given you a sense of what we have, and that each of these contributions are hopefully full of good researched scholarly views which can open up discussions as well as make contributions in and of their own selves.
Wow, excellent. Thank you, Dr. Alireza Bhojani. I mean, it was wonderful. I think you help many people who really love to buy the book and cannot afford to buy the book to get to know what the book is all about, and what each chapter's main arguments are. And so thank you for that. I'm sure everyone would appreciate that much of details and insight of the book. As a last question, briefly, who would you recommend this book to?
Sure. So I think the book is written, of course, it's written for an educated, interested audience, which was the original impetus, was to shine a light, onto these advanced theoretical discussions. Of course, some of the discussions are advanced and are theoretical and are technical. Others are much more accessible. So I think any interested reader, okay, anybody interested in Islamic law, anybody interested in Sharia, anybody who wants an insight into the cutting edge thinking going on, okay, in Shia thought, okay, ought to, visit at least some of the chapters within this book. Of course, it will be of special interest to those who have an interest in Islamic legal theory, okay, Islamic law, even Islamic theology and philosophy, and certainly students of the Hawza and serious seekers of knowledge beyond academia.